Morning and welcome to the fifth session in the Elder Law Training Series for 2024. This series is presented by Pro Seniors in the Ohio Department of Aging in collaboration with the Ohio Training Advisory Committee of the Alliance of Ohio Legal Aids. A couple tech tips. This is probably familiar for many of you because it's the fifth session, but we will be giving CLE credit for attorney attendees for Ohio during this session. In order to get your CLE credits, you need to respond to the polling questions when they come up and the survey at the end of the session. We'll also be recording this session. All the recordings and materials are in a shared folder. I'll drop the link to that in the chat in just a few minutes. And if you have questions for Miriam during the presentation, please put them in the chat. We'll be monitoring that, and we will let Miriam know when your questions come in when she has breaks in the presentation. All right, and with that, I think we can get started. I will pass it over to Miriam Sheline from Pro Seniors to talk about nursing home litigation today.
Okay. Morning, everyone. As Melissa said, welcome to our fifth session, our last session before our summer break. Feel free to take a look at the schedule. We will resume again in September and talking about Social Security, Medicare, veterans benefits, and reverse mortgages through September and October. But today we are going to get into some nitty-gritty about nursing home litigation. I'm going to break this into basically two separate categories we're going to talk about. One is going to be litigation defense. We did talk a lot about discharge process last time, so we will sort of do a summary of that. But then we also have suits against third parties. So these are family members, attorneys, guardians, people who are sued by the nursing home when there is a debt owed beyond just the resident. That frequently also includes the Fraudulent Transfer Act, which we'll go into detail about. And then, having discussed all the various defenses that you can bring with regard to these debt collection lawsuits, we will talk about, are there some affirmative remedies that you can seek on behalf of the client against the nursing home and against the debt collection attorneys. So we have talked about, we'll go through again some of the affirmative remedies that you've got with regard to your residents' rights provisions. But then we'll spend some time on the Consumer Sales Practices Act, how that applies to nursing homes and their debt collection, as well as the Fair Debt Collection Practices Act, which is affirmative litigation against the attorneys for the nursing home. All right, so let's get started with our residents' rights. Again, we went in detail last time about this, but basically there are 36 listed, which break into personal, financial, and discharge rights. Personal were things like safe and clean living environment, free from abuse, adequate, appropriate care, participating in decisions. And I should add, based on their capacity. So nursing home residents are to be met where they are, and simply because even if they have a guardian or they can't make informed medical decisions, they're still entitled to participate in those care conferences, have their records kept confidential, privacy during treatment, the right to exercise their civil rights, private unrestricted communications, choose their own pharmacist, right to consume some alcohol, tobacco, as long as it doesn't violate a doctor's policy or a written policy of the facility, the right to get up and go to bed when they wish, as long as they're not disturbing others, the right to participate in religious, cultural, social activities, the right to voice grievances, the right to report, to have their health changes reported to their sponsor within 12 hours. All right, with regard to financial, they have the right to a full disclosure of the nursing home rates and charges. They've got a right to a 30-day notice before changes. They have the right to receive an itemized bill, the right to be free from financial exploitation. Certainly over the years, we have had nursing homes who unfortunately misappropriated trust accounts. And in fact, there's a bankruptcy pending with regard to 5 nursing homes that covers 3 or 4 states. And that nursing home did not list the resident trust accounts as a trust account and property of the residents in their bankruptcy filings. And so there was a proposal to sell the homes, and literally discharge all claims so that the new nursing home could own that property, clearly in violation of law. But we had to sort of step in and get that corrected. And now that nursing home is apparently not buying it. And we're up to a new one. So we'll have to see what that means. But there are situations like that with regard to financial exploitation, unfortunately, with regard to our nursing homes. It includes when they have a trust account for the resident to a quarterly accounting statements, which shows all funds, all property that the nursing home has on deposit, all deposits, all withdrawals, including receipts, and unrestricted access to their property at reasonable hours. Then with regard to discharge, we spent quite a bit of time with regard to discharge last time. But basically, we start with the premise that you have the right not to be discharged or transferred unless. So we start with the positive, you cannot be discharged unless the nursing home proves that they, A, cannot meet the resident's needs, B, that the resident no longer needs a nursing home level of care, that the health or safety of others are at risk, or unfortunately, the most common that we see on the legal side is failure to pay for care. But again, that means both a Medicaid application is denied and, if appealed, denial upheld. So with regard to a nursing home discharge, filing the first Medicaid application immediately prior to your discharge hearing moots the discharge hearing. They can't do it. And of course, with regard to an appeal, you have 90 days to appeal a denial of Medicaid. In addition, we have discharge plan rights that are now included, which means that it's phrased as the right not to be transferred or discharged to a location that's incapable of meeting the resident's needs or without adequate preparation, including medication, equipment, healthcare services, etc. And then, of course, all the federal rights. These 2 additions are going to be key when we're looking at our defense in our example that we provided last time. So how's it done? They have to give a notice. It has to be in writing. It has to state the reasons, the date, and the proposed location. The right to an impartial hearing and how that will work and how they can request it. A statement that the resident will not be transferred or discharged before the date in the notice unless they agree otherwise. The address of the Legal Services Office and the Department of Health, and the name, address, and phone number of the state long-term care ombudsman. How does that work? They must serve that written notice that meets that criteria on the sponsor by certified mail and on the resident, and send a copy to the Department of Health. Again, served 30 days prior to the proposed transfer date. As we said, they do have hearing rights, that they can request a hearing within 30 days of receipt of the notice. But practically speaking, you want that request being done long prior to the actual discharge date, because you don't want the resident being discharged and then you're having a hearing on that issue to have them sent back to the facility. We're trying to avoid that transfer back and forth. After a discharge decision, the resident or the facility can appeal to the common pleas court filed in the county in which the home is located, because if they're indigent, they can request filing fees be waived. Has to be served on the department and the court within 30 days after the hearing. Again, practically speaking, you need to file your notice of appeal and request a stay of the discharge while the case is pending before the actual discharge date. Who can enforce those rights? A sponsor may enforce, and note that is a sponsor, someone that the resident has designated to be their surrogate is the federal terminology. And that's all that's required is the sponsor may enforce, and any attempt to waive those rights is void. So let's talk a little bit about what the nursing home has also tried to use this same appeal in a recent case up in Cuyahoga County, Lake County, in which they're trying to seek a court order or an injunction by using the same statute to force a resident to be evicted. And of course, as I said, here's the statute that allows them to commence a civil action, but it's to what? Enforce the decision of the department or the court. And if the court finds the resident has not complied with the decision, it shall enjoin the violation and order other appropriate relief. So this nursing home filed a court action, the debt collection action, but also seeking to enforce their discharge notice by seeking a court order forcing the resident to leave the facility, and seeking a court order for the resident's son, who they allege has wrongfully failed to remove the resident, even though there's a discharge notice. Well, again, we already indicate the sponsor is to enforce the resident's rights. That is not the same as obligating the sponsor to remove a resident. And they're claiming that the facility is entitled to a temporary restraining order or an injunction enjoining the resident from remaining in the facility, and mandating the son remove the resident from the community, and seeking that in their relief requested in that complaint. So what are our remedies legally? Well, as we reviewed with regard to the discharge process, what the new discharge right includes the right not to be transferred to a location that cannot meet the resident's needs or with adequate preparation. Nowhere in this complaint have they indicated that they have done so, and the reason is because their notice clearly does not provide for that. It provides for transferring the resident to the son's home. So the court doesn't have any authority to enforce one provision in order to violate the resident's rights. And how do we enforce that? Again, under 3721.17, there is a private right of action, which includes compensatory and punitive damages, but also includes injunctive relief. So as a defense, the attorney for the resident can certainly seek an injunctive relief under the statute, saying, I want an injunction preventing the facility from trying to do this. And of course, if you're seeking injunctive relief, you can ask for attorney's fees. So let's take a look at our fact pattern, similar to what we had last time. Mrs. Jones suffered a heart attack and fell. She broke her hip. In this case, she enters ABC nursing facility, but she suffers from dementia. She's married. Her husband is 80 years old, lives in a two-story home, uses a walker. Mr. Jones signed the admission agreement as her sponsor. He does not have a POA for Mrs. Jones. Nursing home transfers Mrs. Jones without notice to a sister home several miles away from Mr. Jones. I have actually had this fact pattern occur. Mr. Jones requested a state hearing to challenge the discharge, and the nursing home claimed, well, he had no legal authority to enforce Mrs. Jones' resident rights, even though he is designated as her sponsor. Although the ombudsman can assist him with the state hearing, can Mr. Jones prevent future attempts to discharge Mrs. Jones? So that brings us to our first poll question. I'm early today, so.
All right. Savannah, can you go ahead and launch that first question?
So essentially, does he have the standing to prevent? He does a statement is true or false. Does he not have the standing to prevent Mrs. Jones from being transferred because he does not have POA? Is that true or is that false?
All right, we'll give everyone just a few more seconds, and then Savannah, you can shut down the poll. All right, Savannah, if you shut it down and share the results. Miriam, can you see the results?
Yes. So, all right. So most of you are correct, and I know it was a super negative question there, but Mr. Jones, as her sponsor, can enforce her rights. Okay. On the legal side of that, we would also call that being her next friend, which is certainly also authorized. But yes, he still has the right as her sponsor to enforce her rights.
Miriam, there's a question in the chat
Yes.
from Robert. The question is, does the nursing home have the right to demand a resident's Social Security disability benefit while the nursing home is receiving all the Medicaid amount?
Okay. So even though someone is being paid by Medicaid, or the facility is being paid by Medicaid, you are still obligated to pay essentially your income minus your personal needs allowance to the facility. And then Medicaid pays the rest. So in answer to that question, yes, all but exempt numbers, which is $50 for your PNA, unless you're on SSI, at which point it's actually just reduced down to 30. But on Social Security disability, all but $50 needs to be paid to the facility, unless you're a veteran, at which point you're also entitled, and you're getting veterans benefits, you're entitled to that extra 90. Or if you've got Medicare, I should say Medicare supplemental premiums or insurance premiums that have to be paid. And then, of course, there is the exception we talk about and we'll bring up again, which is if you have unpaid medical expenses, you can certainly put into JFS to bring your patient liability down to zero, so that you can use keep your income and use that to pay unpaid medical expenses. But yes, the facility is not demanding it. They're not getting paid that. Okay. And frequently it could be that situation where the facility is now going to be requesting to be representative payee, for instance, so that is paid to them. Okay. Other questions?
Hold on just a second.
Sure.
Yes, there's a question from Mary. ODJFS upon application admission will set the amount the resident pays after reviewing the documentation, correct?
That is correct. They will, after when you submit documentation, that's going to include your sources of income, and they're looking at gross income, not net income. And from that number, they will do the calculation to set the patient liability that you're obligated to pay to the facility.
That looks like it for now.
All right. So let's move on to our litigation defense when we're talking about collection by the nursing facility. So when we look at defenses, we're gonna look at who they sue. Starting off, first they sue the resident, of course, but they also sign anyone who has signed the admission agreement. They will sue family members and the spouse. They will sue responsible parties or sponsors. They will sue the power of attorney, the attorney in fact. They have sued the guardian, and they sued the client's, the resident's attorney. So we're going to look at case law and defenses to these kind of lawsuits. We start with the nursing home admission agreements, and there are terms that are prohibited under the Nursing Home Reform Act, under the federal law. Third-party guarantee as a condition, and of course, guarantee is the key word, as a condition of admission is prohibited. That sounds really good, but nursing homes have lawyers who find ways around that. So you cannot require the resident to waive rights to seek Medicaid as well. That's normally not an issue we see, but the third-party guarantee is. Under the regulation, sorry, I went too fast. Sorry about that. Under the statute, however, the federal statute, you can require an individual who has legal access to sign the contract to provide payment without incurring personal liability. Again, seems pretty clear, but that's what they get paid to do. Anyway, the regulation goes even further, that the facility is not permitted to even request or require a third-party guarantee, but they can request a representative who has legal access to sign the contract that they will pay from the resident's resources without incurring personal financial liability. Similarly, under Ohio law, the provider agreements with Medicaid provides, or ODM says, that the nursing home shall not charge fees to apply for Medicaid, shall not charge a Medicaid individual an admission fee, or charge a Medicaid individual an advance deposit, or require a third party to accept personal responsibility for paying the facility. But again, they may require the representative who has legal access to sign a contract without incurring personal financial liability. So what does that mean? Nursing homes will make the argument and have that the sponsor who has access is signed to agree to use the resident's funds and to cooperate with Medicaid. And since Medicaid was denied, or for instance, the sponsor used some of the funds to pay for the funeral or prepay exempt provisions or accept transfers under Medicaid, and Medicaid is then denied, they will say that you, sponsor, we're not suing you for personal liability, we're suing you for a breach of contract because you didn't pay the resident's funds. That is the essential argument. And the argument is, well, if you're required to sign the contract must mean something. And so without personal financial liability doesn't really mean that. And depends on your court as to whether that argument is successful. But let's go to voluntary. As we indicated, the provisions also allow you to voluntarily make payments. So you may voluntarily make payments. Does that mean that there's a voluntary agreement to be liable. Is that the same? So typical language in our admission agreements that we see, they say these things that being a sponsor, you're not personally liable, you're not personally financially liable, but then impose contractual obligations so that they will sue you, the sponsor, as under breach of contract. Now, some cases have finally come back to push back on this interpretation. So we have out of the second district, Village at Green, that says, hey, you cannot impose personal liability on the sponsor, even where there are contractual provisions. In that case, however, the contractual provision was that you will pay for those out of your own resources. And so there are other cases that are trying to distinguish it on that basis, saying that's the part that's illegal. That doesn't mean you can't sue them for breach of contract. Again, a very recent case, 2023, out of the third district. Provisions in the agreement providing that the representative agrees to pay from his or own resources as a result of the failure to cooperate Medicaid eligibility or retermination process is unenforceable because those contravene the Nursing Home Reform Act and Ohio's version of that. So, but this is where they're trying to split the hair to say, well, the provision in the contract that's invalid is saying that you will agree to pay from his or her own resources, any unpaid charges, because you failed to do certain things. So they take that provision out, but then they still sue the sponsor because Medicaid was denied. Therefore, you must not have cooperated. And you are now tasked with the obligation to prove that that was the case, or you didn't pay resources of the resident. Even if those are appropriate and even if those are done for the purpose of getting the facility paid through Medicaid, they will still make the argument, well, even if they're handling the Medicaid and it doesn't go through, even on their fault, all they're doing is assisting you. It was your primary obligation to get her approved for Medicaid. You didn't, and you paid some other creditor or spent money even on their behalf rather than pay the facility. So you, sponsor, are personally liable. Now, in that national church argument, they made that argument that they're not suing out of personal guarantee, but rather for their, quote, expectation damages caused by the breach of contract with the sponsor. And basically, at least in the third district, under this case, they found that argument to be feckless. But again, that's in the third district. That is not necessarily in every jurisdiction or every district, unfortunately. Even in the second district, if you replace the admissions agreement with a promissory note, the facility can sue on the promissory note. So you said, in this case, the husband was told, we're going to discharge your wife, but we won't discharge her if you sign this promissory note for what's due. And then later, he didn't, fulfill his obligation on the promissory note. So they sued him on the promissory note, and the court said, that's fine. So what are we seeing under the current admission agreements? These have become so much, quote, simpler in that they give you what you're signing on page 1, and you're signing 1 page. But they attach to this, you're agreeing to page 1 plus all these exhibits that are attached. One of those exhibits frequently is this personal guarantee. It will say something like, facility cannot continue to provide services without payment. So many people wish to make sure that the care and services of their loved ones are maintained. So therefore, you agree to make payments on their behalf in those instances by essentially personally guaranteeing the debt. And they will have it in bold. But again, like I said, it's usually exhibit 4 or 5, and it's 4 or 5 pages down. By signing below, you are agreeing to voluntarily personally guarantee payments to the facility, to be jointly and severally liable, and to make all payments when they come due. That they're not required by law to do it, but they're agreeing to do it anyway. In that situation, the court in the 5th District found that they signed the guarantee and therefore they were liable. Now, as we indicated on the statute, it says that you agree to voluntarily make payments. I would maintain that is not the same as signing a guarantee to be personally liable. But right now, the courts are equating the two. As the court Glassmeyer said, by signing the agreement and Exhibit A, which provided the appellant was not required by law to personally guarantee the payment. Therefore, it was voluntary, and there was no evidence that the facility required it, just because they handed you a packet of forms in which it was one of the exhibits. And therefore, the family member was found personally liable. So, how do we defend some of these? And number one is to look at the signature. So, the signature frequently is key. And there's been lots of case law regarding the signature. We have to start with the premise, obviously, that if it's unambiguous, then you can't go beyond the 4 corners of the contract. And in that case, signing your own name without any designation was found personal liability. However, if the signature is ambiguous, then you can look at parole evidence as to what was meant by that signature. And in that case, the husband signed the resident's name, his wife, by him. And the court found that to be ambiguous. But then we come to Dearth Homes versus Klein. And basically that was a guarantee kind of signature. But all they had on that signature line was the family member sign as sponsor. And there was no signature on the resident line for resident. So the resident line was blank. And the court basically said, if there's no signature for the resident, there's no contract. Okay. And without a contract, then there was nothing to guarantee. Now, nursing home attorneys have tried to argue that, well, we're not suing on the guarantee, we're suing on the breach of contract by the sponsor. But the position is still, but there is no contract, which is what Dearth Homes says. It's not limited to just guarantee, it's basic contract law. And if the resident hasn't signed the contract, there is no contract. As a follow-up case, which was out of Franklin County, Alter Care versus Turner, we should call it Turner. Guarantees are unenforceable because why? The contracts underlying the guarantee, the residency agreements, do not exist. And therefore, there is no obligation to guarantee. In that case, I think there was a separate signature for guarantor and no signature for the resident. So, what we have seen now under these new contracts is, in addition to one of the exhibits, they will have one line there for the individual to sign. And by the way, they're frequently saying you can do this electronically, which if you guys have gone to your doctor's offices recently, they just tell you what it says. They don't even actually show you the written contract you're signing, and you electronically sign it on a little electronic pad. That is, we've also seen those via DocuSign or etc. So new twists on that, but that's what they're doing is one line that says resident/sponsor. So let's look at our fact pattern. Mrs. Jones, again, she suffers from dementia. She's married. Her husband signed the admission agreement as her sponsor. He signed on the sponsor line individually, and she did not sign. He does not have POA for her. Now, Medicaid was denied, and Mrs. Jones owes the facility its private pay rate of $100,000, and the facility's attorney sues Mr. Jones for breach of contract. So we are ready for poll question number 2. Is Mr. Jones liable for Mrs. Jones' nursing home debt? Yes, because he signed the contract. Yes, because he was authorized to sign the contract as the spouse. No, because he was not authorized to sign the contract and Mrs. Jones did not sign the contract. Yes, because the nursing home is entitled to be paid.
All right, I'll give everyone just a few more seconds. Get your answers in. Okay, Savannah, can you close the poll and share the results?
Okay. All right. So, no, because he was not authorized to sign the contract is what we maintain the correct answer. Does that mean that I don't have a court who, because of number 4, because the nursing home is entitled to be paid, okay, come up with that rationale, okay? But the correct answer should be he was not authorized to sign the contract. He did not have a power of attorney. Simply because you are a sponsor, that means you are a right to enforce the resident's rights. That does not give you legal authority to sign on behalf of the resident or authorize the resident's obligation on the nursing home contract. Okay, that requires a financial power of attorney to have that authority. Being the spouse, and I've unfortunately had a court make that determination, but being the spouse does not authorize you to bind your spouse on a legal contract. And that doesn't change for nursing home contracts, right? So we have the Mr. Jones who signed on the sponsor line, no signature for the resident, is to provide services to her, okay? So let's review some other defenses when we talk about breach of contract. What do they have to prove? This is, I know, contract 101, but unfortunately, you do frequently have to teach your courts what they learned in law school many years ago. Breach of contract, you must prove the existence of a contract, performance by the plaintiff, breach by the defendant, and resulting damages to the plaintiff. And in order to form the contract, what? Offer, acceptance, and consideration. So what is it when Mr. Jones signed as sponsor? What is that? That is he has made the offer. And as you read those contracts, that's what it says is that the resident agrees that the sponsor may act on behalf of the resident. Well, if the resident didn't sign it, the resident did not accept the family member's offer to be the sponsor. What about consideration? So you have a contract signed by Mr. Jones to be sponsor, nothing by the resident, and you have a signature by the facility. Can they hold Mr. Jones liable for his obligations under that contract in which he signed to act on behalf of the resident. Is there consideration for his promises under that contract, that he would do certain things on behalf of the resident? The answer is, what is the consideration here? The consideration is payment for services provided to the resident. Can a third party be bound on a contract that the resident didn't sign? That requires independent consideration. Simply a written gratuitous promise, even if it evidences an intent to be bound, is not a contract. You need independent, direct consideration between the family member for services that are going to be provided somehow to the family member. Services being provided to their loved one is not consideration. That's a desire to help. And in the Carlisle case, that is essentially, it was not a nursing home case, but it was a spouse who signed a loan, and the court said, or a family member, it was a family member. It was like, well, that's not, obviously she wants to help, but that's not consideration for services to her. Right. So we have the defense of there's no contract because this is an offer not accepted, and that there's no independent consideration. I will say at the lower level, because there are courts who are looking at, gee, nursing homes deserves to be paid, it's entitled to be paid, will make decisions, that the spouse signed on behalf of her husband, in our case, and therefore somehow the husband was, the spouse was able to do that. We've had the same with, the son was signing to provide services to his mother. Again, that is not an independent consideration. So we'll not say that there are not headwinds, but this is the basic contracts 101. All right, we've said there are cases out there where they tried to sue the guardian. And the case law was that you have to file exceptions to the final account in order to bring a claim of negligence against the guardian, i.e. that the guardian, same as we're talking about, use the remaining funds to pay for the ward's funeral, which is permitted under Medicaid, and then close the account, closed off the guardianship, terminated the guardianship, did not pay the facility. Medicaid was denied. The facility goes after the guardian for negligence in not getting Medicaid approved. And in that case, the court said, hey, you had to bring a claim of negligence before the final account was filed because they're discharged. However, in a more recent case out of the 5th District, the court said that the creditor can set aside an account for good cause, i.e. we weren't told about the final account, or we didn't receive notice of the final account. What about the attorney? In this case, the attorney signed his name and then comma attorney and scratched out guarantor. There was no personal liability in that case. All right, so before I move on to the financial power of attorneys, and yes, even if they don't sign them, these people are frequently sued as well. Do we have any additional questions on the breach of contract defenses?
Don't see any questions at the moment.
Okay, great. Well, we will move on. Okay, just checking my time, sorry. So, under the financial power of attorney statute, if the financial power of attorney enters the contract in their representative capacity, within their authority, and discloses that capacity in the contract, so knowledge of the nursing home that you POA is not sufficient, then there is no personal liability. How you disclose the representative nature in the contract is simply put after your signature AIF POA, or indicating the representative capacity following the signature. That is sufficient. So you would think if you sign as POA on the resident line, which is how it should be, that would be sufficient. But there are exceptions: that you agreed to be personally liable, that you have the duty of support, that your negligence caused the debt or beyond your authority. And of course, number 3 is the key. In this contract as sponsor, you're saying that you will cooperate in the Medicaid process. Medicaid is denied, and the nursing home sues you because of negligence. Now, it could be their negligence that caused it, but they're only tasked with assisting you and providing services. So the fact that they were negligent is not necessarily a defense. And of course, the problem is that our attorneys, our family member has to defend these lawsuits, frequently at great expense, in order to prove that they didn't misappropriate funds, or they didn't, or they did cooperate in the Medicaid process, et cetera. In order, so they're dug into litigation, the trial, essentially, in order to defend themselves, which many of our family members who were thought, all I'm doing is signing to get my mom or dad into the nursing home, is just, basically bankrupting them on the other side of it. So some theories that nursing homes have used: one is trying to sue that they violated their fiduciary duty. And the courts have recognized that the fiduciary duty is to your principal and not to the third party. So a breach of a fiduciary duty by the attorney, in fact, is not something that the nursing home can bring on behalf, essentially on behalf of the principal, because now they're not paid. So we can sue the POA on that basis, and the courts have been pretty strong about that. No, the fiduciary duty is owed to the resident, not to the nursing home. What about just suing with regard to family members or the spouse? In general, just because you're a family member, you're not liable for the debts of another. The exception, of course, is the spouse under Ohio's necessary statute, which is 310303. And the Supreme Court has said that includes nursing home debt, or nursing home medical necessary, which includes nursing home debt. So even when she has not signed the agreement, they can sue the spouse for nursing home debt. What are the defenses? Number 1, the nursing home must pursue the resident first before seeking collection from the spouse. They can't say, well, we already know the resident is uncollectible, so we can just skip over that. The Supreme Court was clear in Embassy Health versus Bell. They must pursue collection from the resident first. And in the case where the resident has already died, that claim goes to the resident's estate. Oh, well, there's no assets in the estate, so we don't have to bother with that. The Supreme Court has said, yes, you do have to bother with that. You must open an estate and present your claim to that estate before you sue the spouse. Under probate law, the statute of limitations is 6 months. If you have not presented your claim to the estate within 6 months, that claim is barred. And if it's barred against the estate, it is also barred against the spouse. All right. Before we move on to fraudulent transfers, let's see if there's any other questions on defenses on the nursing home litigation or nursing home lawsuits.
It looks like there's a question in the Q&A. If the spouse always is the spouse always going to be responsible in Ohio based upon the necessaries doctrine?
So what the statute actually says is that the resident is primarily responsible. Only if the resident is unable to pay, then the spouse and someone provides necessaries, then the spouse can be held responsible up to the amount of her ability to pay. So there are two limitations in that. Unfortunately, up to her ability to pay, again, the courts have been pretty liberal on the nursing home side by saying, well, you own a house, so you have the ability to pay. But that is the essential of the Ohio statute. We have been looking at and considering litigation. We have some pending right now as to whether or not this statute violates the Federal Equal Credit Opportunity Act, because essentially it is imposing liability on a spouse based solely on marital status. In Ohio, we have a footnote that indicated that does violate ECOA. At the same time, there's been other federal cases in the Sixth Circuit at this point that have said that it does not, and for a variety of reasons. One of those being, is the spouse an applicant for credit, et cetera. So anyway, that gets into much more of the weeds. I cannot tell you how that's going to play out at this point in time. But for now, that's what the statute is.
We have one more question, Mary.
Sure.
Robert's asking, is it a factor if the nursing home in effect punishes the resident for non-payment by taking retribution with poor care when the resident is pushing back against payment?
So in that situation, that's a reach out to our ombudsman immediately anytime there's care issues. They cannot punish, and that would be a violation of the residents' rights statute, okay? Which at that point in time, you can seek compensatory damages for any damages occurred. You can seek injunctive relief. So those two issues are separate. Nursing home is not allowed to change care based on payer source, including non-payment. So this is why we see this other example of nursing home lawyers trying to use the law to forcibly evict a non-paying resident through court order. Okay, we shall move on here about fraudulent transfers. Okay. Fraudulent transfers is a statutory remedy, okay, and is much broader than what you would consider to be fraudulent in the traditional sense. So any transfer made, whether the creditor's claim is before or within 4 years after the transfer, and they made actual intent to defraud, or they did not receive reasonably equivalent value, and if any of the following apply. They engaged or were about to engage in a business for which their remaining assets would be unreasonably small, or the debtor reasonably should have believed he would incur debts beyond his ability to pay. So you do not have to prove actual intent. Simply transferring it for less than fair market value, and then within 4 years, you should have believed you would incur debts beyond your ability to pay so that you are insolvent, triggers the Fraudulent Transfer Act. Under actual intent, there are factors, i.e. transfers to an insider, debtor retains possession, debtor had been sued or threatened with suit, whether transfers of substantially all of your assets, whether consideration was unreasonably small, whether you became insolvent, whether the transfer occurred or shortly before, shortly after substantial debt was incurred. These are to prove actual intent, what we call badges of fraud. If the debtor made the transfer without receiving reasonable equivalent value, and the debtor was insolvent because of the transfer, then that is going to trigger also a fraudulent transfer. So in Hamilton County, we have the case of Life Sphere versus Sand. This was a mother who transferred her home to her son. I believe he was a disabled son. And the nursing home came back to claim that this was a fraudulent transfer, even though the transfer occurred some significant time before the nursing home event or the illness that created the nursing home event, and there was no intent to do this transfer because she knew she was going into a nursing home. Like the court, and the other argument was, well, it was an exempt transfer because he's an adult disabled child. The first district basically looked at the language of the Fraudulent Transfer Act, saying, hey, you either intended or believed or reasonably should have believed that you would incur debts beyond your ability to pay, and you did not receive value. Medicaid analysis, although may be relevant, in that case, the son did not appeal the denial of the improper transfer determination by Medicaid to show that he was a disabled child, and therefore the court basically said, well, we really don't care what happens with Medicaid, but if you had proven that, then it might have been fine and she would have been on Medicaid and there would have been a debt that incurred. What about age as a factor? And this goes to, should she reasonably have anticipated that she would incur debts? And the answer was, well, she was healthy, she was fine, there was no issues. This illness that ended her up in the nursing home happened a year later, whatever. And basically the court said, anyone of any age who transfers their major asset without consideration is liable to creditors who shortly thereafter extend credit. And in her situation, simply because she was 80, she reasonably should have believed that she would incur debts beyond her ability to pay. Anyone who's 80 or older should reasonably believe that you could enter a nursing home in the near future or require some other form of major medical treatment. And based on that, that becomes a fraudulent transfer. What about the case where a son who had POA transferred it? Does that exempt it with regard to a fraudulent conveyance? Because obviously the resident didn't do it. And the court has said no. The attorney, in fact, also qualifies as a debtor. And in fact, where it's appropriate, you can seek punitive damages as attorney's fees in a fraudulent conveyance case. All right. Other than the Fraudulent Transfer Act, we also see numerous claims one of which is unjust enrichment. So the argument is that even where there's a contract, like our case with Mrs. Jones, there is no agreement with Mrs. Jones, but she is still unjustly enriched by the services she has been provided. Actually, that's a quantum merit argument, but distinguishing those for our courts can frequently be a waste of time. And generally, they're using unjust enrichment rather than quantum merit as those arguments. We also see promissory estoppel. Argument that, even if there is no contract with Mr. Jones or the son, for instance, he orally promised to pay this debt of his mother's nursing home obligations, a promise upon which the facility relied. And of course, you can dispute through discovery, et cetera, whether or not they actually relied on that. But the initial defense is, if you're going to be responsible for the debt of another, an oral promise is not sufficient. It must be in writing. You cannot bring an action to sue someone for the debt of another unless that agreement is in writing, signed by the party to be charged. We've also seen civil conspiracy. We were talking about our situation where you have paid for the funeral. In this case, while Medicaid was pending, the son put the money into a pooled trust. As we learned in our Medicaid training, a pooled trust is an exempt transfer. And the purpose of that is to maintain the individual's Medicaid eligibility rather than put them over resource and have them denied. In that case, Medicaid was denied for failure to verify something. No one appealed it. And then the nursing home sued not just the son, but also the bank that held the funds under civil conspiracy and fraudulent transfer. So, what are the criteria for civil conspiracy? Civil conspiracy is a malicious combination of two or more persons to injure a third party, resulting in damages. It requires an unlawful act before it can be successful. Courts have interpreted unlawful to be tortious. But if one person could lawfully commit the act, then the act committed by two or more persons cannot support a conspiracy claim, no matter how malicious the conspirators or how great the injury. There must be an underlying unlawful act, which is actionable in the absence of conspiracy. And simply planning on causing the injury, even if successful, does not establish civil conspiracy. So there must be an unlawful act. Again, we have indicated that the courts have interpreted that to be tortious. Well, our statutory discussion on fraudulent transfers has the name in it of fraud. So is that a tortious act? Okay. Is that an unlawful act? Well, we have a case that says if there's no fraudulent transfer, there's no civil conspiracy. Does that mean that if there is a fraudulent transfer based on this constructive statutory remedy, is that a tortious act or an unlawful act to support civil conspiracy? Or is fraudulent transfer actually, regardless of its name, not fraud? As we all recall, fraud actually requires an intent to prove fraud. And a fraudulent conveyance, as we looked at, does not. Does that still qualify as an unlawful act under civil conspiracy? All right. And, it depends, again, unfortunately, on your court, are they looking at, oh, well, the nursing home needs to be paid, so we're going to find that that's a tort, and therefore it applies, or not? Okay, so other defenses.
Miriam, we have a
Yes, go ahead.
question
Sure,
about from a few slides ago.
sure.
Eric was asking, so what do we do if someone who is elderly comes to us with a nursing home collection lawsuit after transferring property without sufficient consideration? How do we counsel them and what should they do at that point?
So, yeah, it's going to frequently depend on the reasoning behind that and where the Medicaid piece comes. Okay. If they've already transferred them and let's say they're incurring significant nursing home debt or whatever, let's say there's an improper transfer, that's going to be probably a problem. Okay. And is the court going to be able to set aside that transfer to the relative? Potentially, yes. I don't think our resident is necessarily in danger because they should not be able to be discharged. And a personal judgment against them, not an issue. But if it's a son or daughter, even in a situation where, let's say, it's appropriate for Medicaid, it's going to be really, can we get them on Medicaid? Okay. What's the defenses to that transfer? As we're sort of dig right into that, defenses as to the damages claim itself. Okay. Is there a contract? Now, with regard to the resident, yeah, you're going to have unjust enrichment, but what's the reasonable value of those services as opposed to their private pay rate? Okay. Do we get them on Medicaid so that there's retroactive coverage? And as we talked about a couple times back, you can submit your unpaid medical expense with the facility to unpaid medical UPME to get that approved. Medicaid can then make their patient liability zero, so their income can be used to pay on the back bill. That can go on for quite a while. In our case as to damages, where we had, an argument where the son had done, as he said, an improper transfer. In this case, it was to get her on Medicaid, and they assessed a large amount against him as of 2 years before she got her Medicaid. Her nursing home bill is actually double that. And during the course of litigation, she was approved for Medicaid. Her income has been paid on her Medicaid, so her $100,000 nursing home bill during litigation has been reduced down to 20. So frequently that may be the goal, is defending in that case, but also getting them on Medicaid so they start getting paid. I would also say, in that case, with regard to the son, if his damages, if the court finds damages against him for breach of contract, and her nursing home bill is now less than what he had supposedly failed to do, that's where we talked about our breach of contract but-for analysis, or I think we're going to do that. So, yes, it should not be forgotten that the other defense may be under the damages piece, which are significant. So I'm going to dig right into that with regard to, private pay rate versus Medicaid reimbursement rate. Private pay rate for nursing homes can be $100 to $150 per day more than what they receive under the Medicaid reimbursement rate. Under an unjust enrichment or quantum merit claim, we're talking about what is the reasonable value of those services. If you're able to establish, hey, they knew she was going to need Medicaid from day one, that's what they intended, they expected to receive. And so this means this should be the reasonable value is the Medicaid reimbursement rate. There is Supreme Court case law that talks about insurance payments. Robinson versus Bates since 2006, that the reasonable value of services is a matter for the jury, an issue of fact. Both the original medical bill and the amount accepted are admissible to prove reasonableness and the necessity of charges rendered for medical and hospital care. So in our scenario, the resident gets approved for Medicaid. She's on Medicaid. They're accepting the Medicaid reimbursement rate. Is it reasonable value to say that she should owe the private pay rate prior to being approved for Medicaid? At least that is the argument. Similarly, what we're talking about, credits for payment made that are made during the pendency of the lawsuit. Expectation damages, or remember, that's what they're seeking against our family member. This is calculated on what we would call the but-for principle. Damages awarded for breach of contract should place the injured party in as good a position as it would have been in but for the breach. Thus, therefore, your damages are limited to the actual loss, which loss must be reasonably established with reasonable certainty. So in the situation where, the son paid for the funeral expenses of, say, $10,000 rather than pay the nursing home is owed $50,000 during the pendency of the claim. From the time the son made the transfer of $10,000, they've received payments of $20,000. They are already compensated for the loss they suffered, but for the son's so-called breach. So there is still the next step that should not be forgotten, and that is under the damages defense. All right, one quick statement about arbitration agreements. Okay, they were hot for a while. They're not nearly as complex as they used to be. But when it comes to a sponsor signing or attorney-in-fact signing, simply being a representative on the contract does not extend to authorizing arbitration agreements. That's outside their authority. All right, I'm going to move on from defense to affirmative litigation we can bring. We already talked about the resident's rights provision and seeking injunctive relief and attorney's fees. So the second piece of this is going to be under the CSPA and under the FD, which is against the nursing home, and then under the FDCPA against the debt collection attorneys. All right, so the CSPA provides that it prohibits unfair, deceptive, or unconscionable acts, meaning, injustice, deception, inequitable business dealings, would be unfair, deceptive, the likelihood of inducing a state of mind in the consumer not in accord with the facts. You do not have to prove an intent. I didn't mean to do that. But they were deceived based on the language. That's all you need to do. What are your remedies? You can seek rescission of the contract or actual economic damages plus non-economic damages up to $5,000. Non-economic means emotional distress. You do not have to prove, like the tort, that there was medical expenses incurred, etc. Just that I was afraid. This made me nauseous. I had sleepless nights over being sued for $100,000. Yeah, it's not going to be hard to prove. Anxiety and emotional distress caused by being wrongfully sued. Then, where there is a rule or a decision published in the public inspection files, you're entitled to 3 times economic damages, or statutory damages of $200. And statutory damages can be per violation. So, for instance, in the case where what we're claiming is a wrongful billing because they are billing the son directly each month, the argument is that every one of those monthly bills is a separate violation. There is a provision that they can make a cure offer, and if they do and you reject it, and your economic damages awarded are less than what they have proposed in their cure offer, then you will lose both treble damages and your non-economic damages and attorney's fees. Now, practically speaking, I have never received a cure offer at this point from nursing homes. So what do we need to bring a claim under the CSPA? You need a consumer, which is a person who engaged in a transaction with the supplier. The supplier is anyone engaged in the business of affecting consumer transaction, whether or not they deal directly with the consumer. Any consumer transaction is any transaction providing goods or services for personal, family, or household purposes, or the solicitation to supply any of those. And the deceptive act can be before, during, or after the transaction. There are still some litigation issues out there about what about the family member, the son or the daughter, or Mr. Jones in our case. Is he actually a consumer because the services were being provided to the resident? And that's still an issue out there. But many of the nursing homes have gone away from arguing that in order to argue other points at this point. There are exclusions, but they are strictly construed. So accountants, doctors, dentists, vets, and their patients that pertain to medical treatment. But so billing issues with regard to even doctors or hospitals are covered by the CSPA and not excluded. What about nursing homes? It was argued, oh, well, they're a medical provider. Does that count? And that does not count, as we will see. Debt collection practices by the original creditor, i.e. the nursing home, are covered. Again, what's the test for deceptive? Is the act going to have the likelihood of inducing in the mind of the consumer a belief not in accord with the facts? So it is based on what the consumer will understand this act to be. It is not what the supplier intended. Nursing homes are subject to the CSPA. And it also covers hospitals or medical service providers, especially in their billing. Now, I bring up Eastgate versus Manier, which is a case we did through common pleas in 2007. The reason I bring it up is because it is published in the public inspection file. In that case, the nursing home, there was a gap because of Medicaid. There was a gap of about 2 months. At that time, it was only about $12,000. They tried to discharge the resident. The resident's daughter and power of attorney said, hey, I'm selling mom's trailer. We should be able to pay this off as soon as it's sold. They said, okay, give us a mortgage on the trailer to cover our $12,000 and we'll stop the discharge. She did that, and within 2 weeks, they issued another discharge and tried to say, well, security for payment is not payment. In addition, the billing went balance forwards on some of the bills, didn't match up with the month prior, could not make sense of those. And after that discharge, which again, I think our ombudsman successfully stopped, They then sued both the daughter and the mother for $40,000, even though what was owed was 12, because they hadn't gotten payment from Medicare or Medicaid yet, so that was the balance owed. Each one of these, the common pleas judge, Ringland at the time, found that they violated the CSPA as deceptive debt collection acts. What about standards under the Fair Debt Collection Practices Act? Can we use those as CSPA violations? The answer is yes. Under Taylor versus First Resolution, basically a deceptive act which would violate the FDCPA also is deceptive under the CSPA. And this includes representations in their debt collection pleadings, which are false, unsubstantiated, or misleading, such that they would tend to mislead or confuse the reasonable, unsophisticated consumer. The Supreme Court has said that also violates the CSPA against the original creditor at that point. Unfortunately, we have a flip decision out of the 12th district that says if that claim and that complaint that we're talking about is, quote, colorable, although there may be good defenses, i.e., there's no contract. We were talking about all these defenses that we've been talking about. Even though there may be good defenses, that's not a violation of the CSPA as being unfair or deceptive. Now, the court in that case does not define what it means by colorable. And I think the problem with that decision is that the CSPA is a strict liability kind of statute. It has nothing to do with intent. And the court was looking at a sort of a frivolous standard. And frequently that's what they do. Oh, well, he wasn't intending to mislead, hence colorable. But instead, the standard should be, is that claim going to have the likelihood of putting in the mind of our consumer something that's not in accord with the facts? Suing for punitive damages when you know you're not going to get punitive damages, for instance, would be an FDCPA violation and also a CSPA violation. All right, under the FDCPA. Now, this is a separate federal statute. It is against the debt collectors, which includes the attorneys. It is not something you can bring against the nursing home. Under the FDCPA, you can provide for statutory damages of $1,000 per action. You cannot stack them like we can under the CSPA. You have a provision for actual damages. These include your emotional distress damages, which are not limited under the FDCPA, and attorney's fees. It covers attorneys who regularly engage in debt collection of consumer debt, hence our nursing home attorneys. It includes attorneys' actions in litigation. So making false or misleading statements in your claims in your complaint are covered. A consumer is defined as any person allegedly obligated to pay a debt. This is clearly going to include our family members who are sued. A debt is any alleged obligation to pay money where the services are primarily for personal, family, or household purposes. So what's a false or misleading representation? Misleading a representation that misleads the character, the amount, or the legal status of any debt. The easy one, of course, is barred by the statute of limitations. That is misrepresenting the legal status. But the amount is looking for compensation, which may be lawfully received for the collection of the debt. So if you're not entitled to attorney's fees, if you're not entitled to 18% interest because there's no contract, if you're not entitled to punitive damages, this can be a basis. The threat to take any legal action that cannot legally be taken, and the use of any deceptive means to collect or attempt to collect any debt. Unfair practices are defined as the collection of any amount not expressly authorized by the contract or permitted by law. So if Ohio law does not allow you to get attorney's fees on a consumer contract and you do so, that is going to be a violation. Adding to judgment collection fees or excessive interest or late fees that are not authorized by the contract are also examples. Some basic language here. A violation occurs when a debt collector's representation or action is materially false or misleading and had the purpose of inducing payment by the debtor. Under Snyder, the Sixth Circuit, which basically was a follow-up to a case where they tried to use the necessaries doctrine when they failed to go after the primary debtor. The Sixth Circuit basically found that that was a violation. The Supreme Court had already talked on this issue, and therefore the claim was objectively baseless. Examples of that standard: misquoting a case, relying on a statute no longer in existence, invoking an overruled decision, a claim that the one-year statute of limitations runs for 2 years, or to say that the act does not apply to attorneys collecting debts. These are all examples of objectively baseless. Now, it does not change the overall standard. So something may not be objectively baseless, but still violates the statute because it's likely to induce, in the name of the least sophisticated consumer, a situation that is not in accord with the facts, which is the overall standard. But certainly if it falls under this in the Sixth Circuit, this is also going to work. And note that simply because the lawyer thought it was okay is not a basis. Ignorance of the law is not a defense for debt collection attorneys. And as I mentioned with regard to compensatory damages, it includes emotional pain, suffering, inconvenience, mental anguish, loss of enjoyment of life, etc. So moving quickly through that, but I wanted to get to our last question, our last poll. So Mrs. Jones, again, based on our facts that we had before, she's in the nursing home. He is signed a sponsor. He has been sued for $100,000. The facility's attorney sues him for breach of contract, promissory estoppel, and under the Ohio necessaries statute. Again, Mrs. Jones is still alive, but she was denied Medicaid, and then she was finally approved. So the facility sues her husband under those theories. At our final poll. Does Mr. Jones have a claim against the facility's attorneys for violating the FTCPA? Yes, because the facility never pursued collection for Mrs. Jones. Therefore, no basis to sue Mr. Jones on necessaries. Yes, because there was no contract with Mr. Jones in the facility. Yes, because there was no claim for promissory estoppel. And Mr. Jones cannot promise to be responsible for a debt without a writing. Yes, because the contract violated the Federal Nursing Home Reform Act, or all of the above.
All right. How are we doing? Savannah, does it look like we've got most folks' answers?
Yeah, and I made you, with this poll, made you actually stay for the whole 90 minutes.
We've got 74% participation.
Okay. Couple seconds. All right, Savannah, go ahead and shut it down and share the results, please. Thanks.
Okay. And most of you got all of above. That is correct. You are correct that the facility never pursued collection for Mrs. Jones. And that is a requirement for necessaries. That is absolutely correct. No contract between Mr. Jones and the facility. That is absolutely correct too. He signed as sponsor. He did not have a power of attorney. And she never signed the contract. And they cannot require him to be personally liable for the debt. So all of the above should work, and I certainly would raise all of those. Okay. One final slide here. I wanted to let you know, if you have not seen that, that there has been a CFPB and CMS joint letter regarding these issues with regard to the nursing home, going after third parties. They had a Zoom kind of hearing where there was lots of testimony regarding, nationwide family members being sued on these kind of contracts. And the joint letters expressly disapproved contracts which impose liability on third parties, even as responsible party, and that both of them expect nursing facility admissions practices and debt collection activities to be conducted in accordance with federal law, and instructing the facilities and debt collectors to examine their practices, and that remediate any harms to consumers stemming from violations, and encouraging nursing facilities to notify debt collectors working with them that they are to follow the Fair Debt Collection Practices Act and the Fair Credit Reporting Act for whatever assistance this may be. It could be of assistance in the federal courts. I don't know that the state courts have been very interested in it, but and of course our debt collection. We have not seen our debt collection attorneys changing their activities based on this. But again, it does highlight this is a nationwide problem, and worthy of our attention to attack it as much as we can. So questions, because I know I just went 2 minutes over. Lots of information in there, but lots of case law. I'm hoping that that PDF is available to you, citing lots of cases to give you some insights as to our experiences. But certainly, if there's any questions, I am here. Feel free to join in and let me know.
All right. Don't see any at the moment, but we can give everyone a minute to get their questions in the chat. David, thank you. Yes, thank you, Miriam, for this first part of this series. These last 5 sessions have been great, and we look forward to more to come in the fall. We'll have a bit of a summer break, and then the fall, as Miriam said at the beginning, is focused a good bit on some different types of benefits, right? We'll have some guest presenters in as well.
Okay, yes, and yes, we will be doing, like I said, Social Security, Medicare, veterans benefits, and reverse mortgages will be what we do in September, October. Again, highly relevant senior issues. And so we look forward to everybody joining us, and we can continue our collaboration to be able to address our senior issues statewide. Thank you again for your time.
Right. Thanks, Miriam. Bye, everyone. See you in the fall.